All right. Burnham versus Superior Court. Why is it called Burnham versus Superior Court? In California, if you decide that you are upset with the court, you sue the court. Basically, when the court makes a decision you disagree with, you are not appealing the decision of the other party, so the name of the case will change to reflect that. So when you're appealing the decision of a judge, it becomes X versus Superior Court, X versus Trial Court, X versus Supreme Court. That's just a little thing. They're not actually suing the court here, they're making an appeal, which in California, for whatever reason, is denoted as though you're suing the court, which would kind of reduce the diversity of names available to appeals cases, which does matter. You would be shocked how often cases have repeat names. Can you imagine how many cases there are Johnsons? How many Johnson cases there are? It's going to be kind of annoying that most of them are Johnson versus Superior Court. Anyway, so man gets served with divorce papers while visiting his estranged wife in another state. He gets served. That service counts. Basically, new forms of service, or ones not generally used by the majority of states, are going to be subject to review under that standard of fair play that was established back in the case we just talked about in the other video, Schaefer versus Hetner. But that doesn't matter if these are old, ancient forms of service that have been around forever. We don't need to review them. Right? So in-person service basically is just okay. If you're in that state and you get served, oops, kind of not great for you. You are going to be subject to the jurisdiction of that state.